The suffering of Palestinian and Israeli civilians is the result of Hamas using them as human shields, Israel contends. The Jewish state further lays down conditions for ending the siege of Gaza.
The appalling suffering of civilians, both Israeli and Palestinian, is first and foremost the result of this despicable strategy. The horrible cost of Hamas not only failing to protect its civilians, but actively sacrificing them for its own propaganda and military benefit. And if Hamas abandons this strategy, releases the hostages, lays down its arms, the hostilities and suffering would end.
Presenting an emotive case of the experience of the Israeli population of the 7 October attack by Hamas, Becker said Israel is simply protecting its people and does not have any genocide intent to wipe out the Palestinian population. South Africa, in its submission on Thursday, insisted that Gaza has been turned into a concentration camp where Israel is committing acts of genocide, despite Israel's claims that it means to make Gaza a safe place where Palestinians and Israelis can live in peace and harmony.
Israel had flatly denied South Africa's accusations. Despite these harsh accusations, Israel has persisted in its genocidal acts against the population of Gaza. What more evidence could be required to establish a dispute? It is precisely because of a situation of this kind, affecting the international community as a whole, that Article 9 of the Genocide Convention does not require negotiations as a precondition to seizing the jurisdiction of the court. Certainly, a respondent state cannot prevent a referral to the court by claiming that there is no dispute and that it wants discussions on this matter when the existence of the dispute is clear.
Israel, on its part, argued that the existence of a dispute and jurisdiction of the court should be determined by the date on which South Africa submitted the application to the court.
The court will take into account, in particular, any statements or documents exchanged between the parties, as well as any exchanges made in multilateral settings, the court has said. The key point here is the use of the term exchange between the parties. Unilateral assertion does not suffice. There needs to be some element of engagement between the parties. The element of interchange and bilateral interaction is required.
But Professor Dugard, in his submission, laid out all the communications South Africa initiated with Israel, both bilaterally and at multilateral platforms, when he addressed the question of jurisdiction of the court.